Hi, my name is Stephen Choi. I want to talk to you about your upcoming deposition. At your deposition, the defense attorney will ask you questions that you must answer under oath. What does that mean? It means that you must swear to tell the truth under penalty of perjury. You might have seen this on TV or in the movies where a witness is asked, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? That's what it means to swear to tell the truth. Under penalty of perjury means if you don't tell the truth on a material matter, you could be convicted of a felony. So the first rule in a deposition is tell the truth. All of your questions and answers will be taken down word for word by a certified court reporter using a stenographic machine, which I'll show you in a few seconds. After your deposition is over, the court reporter will type up all of the questions and answers into a little booklet that the defendant can use against you should this case goes to trial. Now let's talk to a real court reporter and see how the stenographic machine works. Hi, this is Ramona, a court reporter. She's going to tell us how she's able to take down all of the questions and answers.
I take it on this little machine, and you don't hear a thing. It's just silently taking down what you say, word for word.
How are you able to take down all of the questions and answers so fast as people are speaking?
Well, I went to school to learn how to do that, and it's just a process of typing on these little keys.
Is that a regular keyboard, or is that some kind of shorthand keyboard?
That is a shorthand keyboard called a stenotype, and you can depress keys down to make a phonetic sound, and that's the way you do it.
And then when the deposition is over, then what do you do?
Well, then it's all computerized, and I just download it onto my computer and then edit the transcript.
And then you prepare a transcript of all the questions and answers.
That's right. It's right in written form.
That's great. That's a very interesting machine. Thank you, Ramona.
All right.
Your deposition will take place at the defense attorney's office. You'll be there, an attorney from our office will be there, the defense attorney will be there, the court reporter will be there, and in 99% of the cases, the defendant will not be there. Your deposition might be videotaped. If it is, we'll let you know before the deposition. It is very important that you appear for your deposition and that you're not late. If you miss your deposition or are very late, you could pay cancellation fees of $1,000 or more. So if the date and time scheduled for your deposition is not convenient for you, please let us know right away. In most cases, we need at least 3 days notice to continue your deposition. So how should you dress for your deposition? You should dress very nicely. Dress as if you're going to a job interview or going to church. You want to create a good first impression. Now, this is doubly true if your deposition is being videotaped, but even if it's not, you still want to dress nicely because you want to create a good first impression. The first thing the defense attorney is going to do after your deposition is write a report that includes a description of you. You don't want to show up in t-shirts and shorts and looking like a slob, and that's what's going to get reported back to the insurance company. You also want to make it very clear that you're taking this case very seriously and that this is an important case. This is a big case. If you don't take your case seriously, no one else will. And this is going to affect your bottom line. We want to convey the impression that this is a big, important case, and therefore we dress appropriately for that. When you're at your deposition, how should you behave? Well, you want to behave politely, and you don't want to be some out-of-control witness. Certain questions might make you upset and mad, but you don't want to lose your cool. A lot of defense attorneys will try to push your buttons to see if they can push you around. They want to know if they can get you on the stand and they can get you to lose your cool, because they know that once you lose your cool, you're bound to say anything. Plus, people don't like angry plaintiffs. They like people who are cool, calm, and have their emotions under control. Do not get upset. If you start getting upset and mad and frustrated at your deposition, your attorney will call timeout and take you outside and tell you to relax. Remember, the defense attorney has a job to do, and that is defending the defense and the defendant's insurance company. They're going to ask you questions that you're not going to like. Do not get upset. Answer them politely. Don't be angry. You want to come off as a very cool, calm, very nice person. Your deposition is the first time that the defense side, the defense attorney, is going to take a look at you and look at your demeanor. And what he's doing, other than just asking you questions, is assessing how good of a witness you're going to be should your case go to trial. And that's a very important question. And all parties always discuss whether or not the plaintiff makes a good witness or not. Because everyone knows that a likable plaintiff is going to get more money from a jury. Juries give money to people they like. They don't give a lot of money to people they don't like. So if you come off as being a very likable person, the defense attorney is going to report that to the insurance company and say, you're a great witness. We need to be concerned that the jury's going to like you, and we better up our settlement demand. If you come off as the most unlikable person in the world, they're going to report back to the insurance company, oh, the plaintiff is very unlikable. She's hard. He or she is very hard to even be with. A jury's going to hate her, hate him or her. They're not going to give him or her much money. So you can see how your demeanor affects the value of your case. Unfortunately, a jury trial is somewhat of a popularity contest. So we want to win that popularity contest. You want to dress nicely, and you want to act in a way that makes the defendants feel, the defense and the defendants feel, that you're going to make a very attractive witness, and the jury's going to like you, and they're going to give you a lot of money. That way, your settlements are going to go up. Do not argue with the defense attorney. If you have any problem with any question, just ask to take a break. We'll go outside. We'll talk more about taking breaks. Make sure all of your answers are in English and out loud. Don't say uh-huh or yeah or nah. That's because the court reporter is not going to be able to take that down accurately. And don't gesture with your hands. If the defense attorney asks you, how far away is the other car? You don't want to say it was this far away or something was this small. And that's because the court reporter is not going to be able to take that down. We want to make sure that the deposition transcript is very clear, and to ensure that your answer should be in English and out loud. You also don't want to talk over the defense attorney. Let the defense attorney finish his or her question before you start answering. In normal conversation, people talk over each other all the time, and sometimes clients forget. If you do forget, your attorney will nudge you and say, please let the defense attorney finish his question before you answer. This is very important. This is not a speed contest. This is very important. This is an important case. You don't need to rush. You want to take your time. Not only do you want to listen to the question so that you know what the appropriate answer should be, but you want to make sure that two people aren't talking at once and the court reporter writes down something wrong, and then we lose the case because of that. So let the defense attorney ask the question before you start talking. If you don't understand or hear one of the questions, it's very important that you tell that to the defense attorney. A lot of times attorneys will ask a bad question, or maybe you just didn't understand it. Whatever the case, you make sure that you tell the attorney, I didn't really understand that. Could you repeat that question? Could you rephrase that question? And let him repeat or rephrase it. If you have any doubt about what the question meant, you should say, please rephrase or repeat it. Because once you answer, they can always use that against you. And I've had many cases where the client gave a bad answer and then later tried to say, well, I didn't understand the question. I thought he or she meant that. And then it just is never good. Just make sure you fully understand and hear the question. And obviously you can take a break because you're getting tired, you have to go to the bathroom, you want to get some water. And at most deposition, breaks are taken regularly. But again, you can always ask to take a break. I want to talk to you now about objections. Throughout your deposition, your attorney might object to a question. There's going to be two kinds of objections you're going to hear. One objection is where the attorney instructs you not to answer, and that's because the question is inappropriate and you don't need to answer. For example, if the other side asks you, what did your attorney tell you to say when you were outside during the break? Objection, this is attorney-client privilege. You don't need to answer that question. Any communications you have between your attorney is completely privileged. Or they can ask you, well, what did you say to your priest during confession? Objection, client-clergy privilege. Anything you say to your priest or religious pastor is privileged. There's even a marital privilege. Anything you say to your spouse is also privileged. The most important thing is not to know all the different objections, but to just follow the advice of your attorney. If your attorney says objection, do not answer that question, then don't answer the question. The attorney is there to help you and guide you and protect your rights. There are other objections where we're just preserving the objection for the record. It may be the form of the question is odd or anything like that. There's an objection called asked and answered if we feel that the question has been asked a number of times. So you might hear objection, this question has already been asked and answered, but I'll let my client answer. So there's going to be some objections where the attorney will say you can answer the question. If your attorney says answer the question, then go ahead and answer the question. One thing that, this is a small bit of advice, but it happens every now and then, and that is the client who is constantly looking at the attorney for answers. And so even once is not a good idea, but you don't want to be the client that is always looking to the attorney for answers. So every question that's asked, they look to the attorney or they look to someone else is there. It's like they don't know what to say and they're looking for help. You know, you don't want to be that kind of witness. It is very important that you give the impression that you're a knowledgeable, credible, and believable witness. And so just look the defense attorney in the eye and answer the question without looking for answers somewhere else. Again, if you need help, we just ask for a break and we'll talk about it outside. What else can you do to prepare for your deposition? 1, you can visit the scene of the accident. You will be asked many questions about the scene of the accident, and it never sounds good when a plaintiff doesn't remember what the scene of the accident looks like. For example, if you were in an auto accident and you don't remember how many lanes of traffic there were, or whether there was a stop sign here or a traffic light there, whether there was a crosswalk, whether there was any trees or bushes blocking your vision, it makes it sound like you're unfamiliar with the scene. Perhaps you got confused and it sounds like the accident was your fault. If you are very familiar with the accident scene, it makes you sound very knowledgeable, very credible, very believable. If you were involved in a slip and fall accident and you don't remember anything about the scene of the accident, it also makes it sound like you were not familiar with the scene and perhaps you were confused or you didn't know where to look and maybe you slipped or tripped because you weren't looking where you were going. Again, it makes it sound like the accident was your fault. It's always better to be a knowledgeable and credible witness. If there was a police report in your case, you want to make sure you read it at least twice, especially the part that talks about what you told the police officer. Make sure you read that at least 3 times. You don't want to say something that's different from what you said in the police report. Again, it makes it sound as if you're changing your testimony and that you're not a reliable witness. We will definitely go over the police report with you when you come into the meeting, but it's important that you review the police report yourself. If you don't have a copy, call our office, we'll send one to you. Make sure you read the police report before your deposition and before you meet with us. If you gave anyone a written statement and you still have a copy, you want to make sure you go over that also. If you don't have a copy, we'll give you one or we'll post it on the website. In fact, all of these documents we'll post on the website so that you can review. But you definitely want to look over to see what you said in any written statement. Your medical records, you want to look at your medical records. You want to review what you told the doctors about your injury. So again, it's very important that we're consistent. It's important that what you told the doctor in the medical records is the same thing you're going to say at your deposition. For example, if you told the doctor that your neck was hurting and at the deposition you say your knee was hurting, then it's very inconsistent and it doesn't sound right. So you want to be consistent. You want to know everything that you told anyone about this accident that is in some kind of record. So again, witness statements, police reports, medical records. Any evidence that you have, you want to review to make sure you're ready for your deposition. Again, your deposition is a very important part of your case, and you want to make sure your testimony is consistent with what you told these other parties and police officer and doctors before. So how else do you prepare for your deposition? Well, you want to start thinking about the answers you're going to give to basic questions. And I want to go over some of the basic questions that you'll be asked so that you're ready. And I want you to think about your answers before you come to meet us. Now, we'll talk later about how you're going to meet with us and what that meeting will involve. We will actually go through all of the questions and answers we think the defense attorney is going to ask you. But we want you to be prepared for that meeting so we make the best use of our time. So here are some basic questions that you're always going to be asked at a deposition and you want to be prepared for. So start thinking about the answers you're going to give. For example, questions about the accident. You want to start thinking about how are you going to answer the question, how did this accident happen? So you're going to have to give your version of all the accident happened. So start thinking about how the accident happened. If you were in an auto accident, start thinking about questions about what you were doing that led up to the accident. Where were you coming from? Where were you going? How did you get from where you started to where the accident happened? How fast you were going? What lane were you in? How many lanes were there? Where did you first see the other driver? Where was the other driver when you first saw the other driver? How fast was everybody going? Where was the impact? Where did the impact take place? How fast were the cars going on impact? What happened after the accident? Where were the cars located? All of these questions, start thinking about them. And of course, we're going to go over this with you specifically when you come to meet us. But we want you to start thinking about those questions now. In terms of your injury, start thinking about these questions. So, when did you first start feeling pain? What part of your body was in pain? Describe the pain. On a scale of 1 to 10, how bad was the pain? How frequent did you get the pain? And how are you doing now? Is your pain getting better, staying the same, getting worse? You'll be asked a lot of questions about what kind of treatment you received. So the defense attorney is going to want to know what doctors you went to, what you were treated for, what kind of testing they performed on you, what kind of treatment did they give you, did you have physical therapy, what kind of physical therapy, what exactly did they do. You'll have to answer questions about what type of prescription medications you were taking. They will ask you questions about what kind of activities you can no longer do because of your injury. So this is actually an important question that they always ask. So, were you not able to do certain activities after the accident that you were able to do before the accident? And so maybe you weren't able to clean the house anymore, play basketball anymore, go hiking anymore. Start thinking about any type of activities you were not able to do after the accident that you could do before the accident. Now, and be prepared to say for how long were you not able to do those activities. So maybe for 3 months after the accident you weren't able to work out, but now you are. Okay, so start thinking about how you're going to answer that question. In terms of describing your pain and suffering and all questions about your injuries, start thinking about how you want to answer those questions. But you will definitely be asked questions about describing your injury, describing your pain. Remember, a large part of your settlement or verdict, if we go to trial, is going to be based on pain and suffering. So you must be prepared to describe to the defense attorney and ultimately to the jury how your pain and suffering felt. And so they will ask you, well, can you describe the pain? It is very important when you describe the pain that you not exaggerate, but you don't want to underestimate. So we have a lot of clients who are, they don't like to complain, and they're asked, how was your pain? And they say, it was not too bad, it was just a little. Well, when they give that answer, that means that their settlement is going to be just a little or very small. So remember, when you are asked a question about how bad your pain is, the reason why they're asking you that question is because they're trying to determine how much money you should get for your pain and suffering. So you want to be able to very much explain your pain. And so start thinking about how you're going to answer that question. How would you describe the pain? And it's always best to give concrete examples. My pain was so bad that I was, it felt stabbing and I couldn't lift my child, and give concrete examples, and we will help you more when you come in to the meeting. But we want you to start thinking about how you're going to answer questions about your pain. As I mentioned earlier, you'll be meeting with us in our office to go over specific aspects of your case. We'll go over every question we think the defense attorney will ask you so that you're fully prepared. Thank you for watching this video. If you have any questions about your deposition, please feel free to ask us. Thank you.